Ready. Hello everyone, my name is Giuseppe Martinico. I'm one of the co-directors of the Sant'Anna Legal Studies program STAS, together with Giacomo Delle Donne and Filippo Fontanelli, and I'm very glad to share this book launch, which is a joint event co-organized with EU Law Life. Let me say that special thanks go to Daniel Sarmiento for hosting, this event. We really admire Euro Live and what this fantastic, reality has done so far. So it is a great honor. It means a lot to us. To have the opportunity to organize this event. I'm also super duper happy because we are gonna present and discuss a fantastic book, Res Judicata in European Union Law. This book was recently published by my friend Araceli Turmo. Araceli is met the conference at Nantes Université. She's a great expert in the field of EU law. She's one of the most interesting voices in this debate. So I'm very happy that we have the opportunity to discuss this very important volume. And we're gonna do that with other two stellar colleagues and friends, namely Xavier Groussot, who is a full professor of EU law at the University of Lund, and Daniel Sarmiento, who is full professor of EU law and administrative law at the University Complutense of Madrid. Let me say a couple of things about the rules of the game. As always, Araceli, so the author of the book, will introduce the book for approximately, I would say, 20 minutes, and then Xavier and Danielle will give their comments. Each discussant has 15 minutes approximately. Having said that, thank you very much to all the speakers for joining us, for accepting the invitation. And I would like to give the floor to Araceli. Please, right where you are.
Thank you. Thank you very much, Giuseppe, for hosting this event. I'm very grateful for the opportunity to discuss the book, and also, of course, my thanks to Daniel Sarmiento and Xavier Groussot, who very kindly accepted the invitation to take part in this event and discuss the book. I'm looking forward to the discussion, to hearing what my two discussants have to say, and also to hearing or reading the audience's questions on the book. The book, I was asked to show a copy of the book. I don't have the nice shelf behind me to advertise it, but I did show it. The book is pretty much meant to be a kind of overall presentation of the doctrine of res judicata as it has been developed and is currently developing. It's an ongoing process in European Union law. It's one of the, I think, of course, it's my topic, one of the most interesting aspects of procedural law in the European Union, because it's something that is entirely absent from the written sources. There's no mention of it in the statutes, in the rules of procedure. And yet, from the get-go, of course, it's obvious to everyone involved, all the members of the court, all the practitioners, lawyers, presenting cases before the court, that of course res judicata must exist if this is going to be a judicial system that works in any way, and that this res judicata will have to operate under rules that have to develop depending on pretty much the reference points of each of the actors involved. So it's a principle that initially isn't presented as a principle. It's presented as something that is kind of there in the case law. Everyone assumes it's there because it must be there. And the way in which it's assumed to function is the way in which the actors involved are used to seeing it function in their legal systems of origin, in the systems in which they were trained, in which they are used to working. And it's interesting to see that although by now we do have a much more coherent, a much more full and detailed system of protection of res judicata in the European Union, it's still very influenced by the specific national trainings and the specific national understandings of res judicata in the way in which it operates at EU law level. And we still find, for example, in Advocate General opinions, references to concepts of res judicata that are not relevant to EU case law, but are relevant to a specific national tradition, whereas EU case law would use a different way of categorizing things or different concepts to talk about the same issue. So a comparative law analysis is basically at the heart of any analysis of res judicata in EU law. And that's one of the things that attracted me to it, because comparative law is, I guess, without being a comparative lawyer, it is a kind of hobby, I would say, for me, because I'm an amateur comparative lawyer. And I really enjoyed, while thinking about res judicata in EU law, trying to find traces, indications in the EU case law of where different aspects of EU law, different aspects of the EU understanding of res judicata came from, and how can we understand them. Now, as I was saying, by now the case law is sufficiently developed that for a number of topics we do have relatively coherent rules, relatively detailed rules, but this is not true for all of the aspects of the doctrine of res judicata. So I mean, anyone familiar with the topic, even in national law, knows that it's a kind of ever-evolving topic, and there are aspects that are constantly being discussed because it's basically a tool, right? Res judicata, as a way of preserving what has been settled by a court in a final judicial decision, is a tool in the hands of the parties or in the hands of judges to regulate the caseload, for instance, of courts, or regulate to what extent legal certainty can be challenged, or regulate to what extent access to courts and effective judicial protection should be guaranteed. And so, of course, policy choices will evolve over time, and with these policy choices, the law of res judicata will change. One topic that is still very current, for example, in French, Luxembourgish law, is the topic of requiring parties to concentrate all of their claims in the first set of judicial proceedings on an issue, and then claiming that, well, if you don't do that, res judicata will bar you from presenting any new claims in later proceedings. Although, in theory, under the traditional understanding of res judicata in these systems, but res judicata did not prevent parties from bringing entirely new claims in a second set of proceedings. So why? Because the French Supreme Court decided at some point we need to reduce the caseload, and therefore we are going to restrict access to courts for second proceedings over the same factual issues. In the European Court of Justice, what's interesting about this case law is that in some aspects it's pretty settled, and so you find some aspects of the doctrine being now consistently applied with very little discussion and very few doubts. And there are other aspects in which it's quite clear that the courts themselves, the General Court and the Court of Justice, don't seem to be either very confident in the choices they're making, or sometimes don't even seem to realize they've already decided that specific point of procedural law. So it's more haphazard in a way. And this is all, of course, talking about EU procedure itself. Res judicata in the way it operates with regard to the judgments of EU courts. Then, of course, you have a whole range of issues that are related to national res judicata, and this is the topic that is usually discussed in EU scholarship. When one talks about res judicata, what one finds most of the time is discussions of the impact of EU law on national res judicata, on the protection of final judicial decisions that are made at the national level. So I discuss this also in my book, but it's one chapter. The rest of the book is really more concerned with the general doctrine of res judicata, or the specific operation of the principle in EU procedure itself. I would say that even with regard to national res judicata and the impact of EU law on national judgments, there are shifts happening in the case law, and in recent years it looks like, again, we have changes happening. Maybe the court is slightly changing its approach to national procedural rules of res judicata, but this is, in my view, related to a more general shift in the approach to national procedural law, and not necessarily to a new understanding of res judicata itself by the Court of Justice. What is true is that, as in other aspects of procedural law, the Court of Justice seems to have this tendency, and it's increasingly happening, to kind of have this idea that there's this European standard for whatever the procedural rule is. So in this case, res judicata. And if a member state has a rule of res judicata that is outside that norm, that standard, that is implicit in the European Court of Justice's case law, well, it's going to be much easier for the court, apparently, to consider it beyond the bounds of what is acceptable with regard to the impact on the effectiveness of EU law. In other words, the court will find that a procedural rule is challengeable under the justification of effectiveness of EU law much more easily if the specific procedural rule is outside what the court considers the norm, the European norm, for whatever the rule is. And this is very present with regard to res judicata. So we have an increasing number of judgments in recent years in which national res judicata rules are challenged without much justification with regard to the actual impact on the effectiveness of EU law, but much more justification with regard to the fact that it seems to the Court of Justice that this is just a little bit outside what you would usually expect to find as the protection of final judgments in a member state. And this is, of course, a source of many potential discussions and reflections on what is the relationship of the Court of Justice with national procedure. I mean, is the Court of Justice legitimate in setting these European standards for procedural norms and expecting the member states to follow them, considering the diversity of the judicial systems and procedural systems in the member states? And the way in which res judicata operates is an interesting beast, if you like, in this sense, because it's both something that is present everywhere. So you can always start from the premise, well, it's present in the EU legal order and in the legal orders of all the member states. Everyone agrees. And some of the basic features are the same. But then the specific detailed rules through which res judicata is enforced are actually quite different, and can evolve in space and time in significant ways. Hence the potential for rules that are outside the norm or outside the kind of consensus approach, and that the Court of Justice will be more likely to challenge if it is asked about the rules. So that's the national res judicata side of the issue. With regard to the EU aspect, which is the one that I guess my book is most useful for in terms of original writing, because there's very, very little writing on the topic. We find that the closest, I would say, the closest judicial system, the closest rules for the functioning of res judicata to the ones that have developed in EU law are clearly French understandings of res judicata, the ones that have developed in French administrative law and administrative procedure, which are heavily influenced by the French civil procedure understanding of res judicata. However, there are aspects in which, and significant aspects in which, EU procedure differs from French procedural law, even with regard to res judicata. This is, of course, the result of the Court of Justice just picking and choosing what seems most suited to each issue as it comes up before the court. And of course, the judicial system is different and has different needs, or different rules might be best suited to the needs of EU courts. But there's a very clear influence, simply even in the vocabulary that's used. And that was one of the challenges, of course, in writing this book in English, is that very clearly the vocabulary used by the Court of Justice with regard to res judicata is French legal vocabulary. The concepts used are French concepts, and it's very hard to translate them into especially English, since English understandings of procedure are based on completely different concepts much of the time. And the court itself finds it difficult, clearly, sometimes to translate its own legal concepts into other languages, and this is true for res judicata also. Another thing that I tried to do in the book is suggest solutions or ways forward with regard to aspects of the law of res judicata that are not quite as settled, or where I would say that the case law does provide answers, but it's not always clear in the case law itself, or in opinions of advocate generals, or even in scholarship, that people are aware that you can already use the case law, the existing case law, to find answers to certain questions. So to me, the aspect of res judicata doctrine in EU law that is perfectly settled is its use as a rule that justifies inadmissibility claims where you have a full identity of parties and claims between the case that was settled by the earlier judgment and the current case. In those situations, the court hasn't changed its position for a long time, and it just applies its test by rote. It's really not discussed, and the criteria seem clear enough. Although, even in this respect, because the court imported the concept from French law of claim, of basically subject matter and claim, that are unclear even in French law and have been the topic of much debate for decades, well, the same debates could be had in EU procedure, and they would be never ending as they are in French law. It's just the concepts that are fuzzy and ill-defined from the start. But luckily, most of the time, the Court of Justice doesn't get into these discussions and just says, well, just basically the factual issue. Is it the same? The legal claims in general, are they the same? And it's very rarely a topic that is difficult in the case law that exists to this day. So in this regard, the use of res judicata as barring admissibility of a claim or of a new suit, of a new case being brought before the EU courts, we have very little doubt as to the applicable law, and much of the procedure is settled through numerous cases. In other ways that res judicata might be used, here we have a lot more questions, a lot more doubt. This is true, for example, in cases where the claim being made or the claim being brought in the new proceedings, or the case being brought to the attention of the court with regard to the earlier judgment is not sufficiently identical. There is some difference, which prevents the use of res judicata as a bar to admissibility. And in those cases, you use res judicata, and it's done at the national level too, as more like a kind of evidentiary point. It's something that is added to the evidence and that should not be called into question because we've already settled this, but it's more like an aspect of an earlier judgment that we should take into account. Or, for example, the issue of the extent of the scope of res judicata in terms of which cases can the claim of res judicata be brought, which cases which cases can res judicata act as a bar to admissibility in. These issues are not necessarily very well settled with regard to earlier judgments that rule on the validity or legality of an EU act. Once again, this is because the EU court has imported some concepts from national procedure, like the concept of absolute res judicata from French law. And because of this, well, we have uncertainties. When does this absolute res judicata operate? What is the difference between this absolute scope with regard to the usual scope of res judicata in admissibility claims, etc. So we do have some doubts that are more relevant to kind of marginal cases, not really the heart of the role of res judicata in EU procedure, but I would say there's a lot of potential for clarification and for a more coherent approach when you depart from this kind of very basic application by rote of the established case law in the most classic, simple case type of case. Another issue that I dealt with in the book, and that I think is an important issue, is the question of whether res judicata applies to preliminary rulings. This is a very traditional point of discussion, especially in certain national traditions of EU scholarship, not in all of them, but in some traditions of national legal scholarship. For example, the French-speaking tradition, there's been this idea that preliminary rulings aren't proper judgments and they produce erga omnes effects. They produce effects because they are statements on the law that have to be taken into account by everyone. And therefore, this is not the way a normal judgment works. So they can't have res judicata. And yet the court has said they do produce this effect. But the court itself doesn't seem quite clear on how this effect should then operate in its own procedure. So the court says they do have it, but then how do we use res judicata if applied to a preliminary ruling? Because of course, normally in EU law, you would be able to bring a claim of inadmissibility, for example, based on res judicata if the parties are identical to an earlier case. How do you find yourself in a situation where you have a new case before the EU courts with identical parties to the case that gave rise to a preliminary ruling? It's not easy unless you have a second preliminary ruling in another set of proceedings or the same set of proceedings involving the same parties. But in that case, if the question is new, there's no bar to admissibility based on res judicata. The court has always said this is acceptable. You can always send new references, right? So we can see, for example, in opinions even by Bobek in recent years, where he's thinking about the issue, kind of struggling through what is precedential value, what is res judicata, not quite finding the words in the case law to answer the question. And I think it's, again, an issue where clarification, a more coherent approach is possible. And there are elements in the case law that we can use to construct such an approach. So it's more a matter of how we read and use the case law that it already exists, rather than a matter of really innovating very much beyond what is already there. So this was just to give you a kind of general overview of the different topics that I talk about in the book. I think I'm going to stop speaking now. I'm not sure how long it's been, but I think it's been 15 to 20 minutes. So
perfect. It has been perfect.
Perfect. Okay. So thank you very much for your attention, and I look forward to hearing the next two speakers.
Awesome. Thanks indeed, Araceli, for this great overview. And now I'll give the floor to Xavier Groussot. Xavier, thanks indeed for
appear again. So thank you. It's a pleasure to be here. And as I was saying before, but silently, I've been following Araceli a long time, and especially her research. And it's just a delight to be able today to discuss the book of Araceli, which I found to be a remarkable piece concerning res judicata. The book is concise, it's precise, it undertakes an in-depth research on one of the most central doctrine of the modern states and of any democratic judicial system. In my view, the book is actually one of the best writing, if not the best writing, on res judicata which has ever been produced in EU law. And this book enlightens us both from a practical and theoretical perspective. So during this presentation, I will divide my presentation in two parts. First, I will explain to you why I like so much this book, and I will provide four reasons for that. And then I will move to a more discursive part. We'll present four topics where Araceli afterwards can come back and comment on the topic that I specially selected because I found them to be extremely interesting. But to come back to my first part and why I like so much the book, the first reason for me liking this book is because the first and most important reason is that the book tackles with clarity the issue of complexity and also deeply reflects on this issue of complexity. As you mentioned, Araceli, during your presentation, you call res judicata a beast. It's a very complex principle. Actually, in Euro doctrine, many people say that the principle of proportionality is the most complex principles. But actually, after reading your book, I would say that res judicata is the most complex principle of EU law. And this complexity has led to a lot of confusion. In the doctrine, in the case law of the Court of Justice, but also, as you say in demi-mot before, in the conclusion or the opinions of the Advocate General. And to understand this complexity, it suffices to look, I think, to the title of the book of Araceli. Res judicata is a multifaceted principle in a multi-level system, which really show the complexity, I think, of the principle of res judicata. And in addition to that, and also mentioned in the presentation by Araceli, the complexity of res judicata in EU law is reflected by the fact that there is no specific provision in the legislation concerning res judicata, in contrast to some national legal system, and especially French law, where you find specific provision like Article 1355 of the Civil Code or Article 480 of the French Code of Civil Procedures. So Araceli's book here provides to me, and also what she says actually in her conclusion, a bolder and more explicit approach when it comes to the understanding of I like so much the book, and the reason why I like so much the book is also because it goes beyond the traditional knowledge that we have on res judicata. It covers all aspects of res judicata: positive, negative res judicata, absolute, relative res judicata, force of res judicata, force de la chose jugée, and autorité de la chose jugée. You name it. This is actually a doctrinal tour de force, a feat of strength here. And here to suffice to look at the chapters 5, 6, 7, and 8 of the book to show that those chapters really bring something new to the classical doctrine on res judicata, which, as also Araceli mentioned previously, is often based on the issue of national procedural autonomy and the balancing between national res judicata against the EU effectiveness, or the balancing between legal certainty and EU legality. My third reason why I like the book, also mentioned actually in the presentation by Araceli, is because it provides a specific recommendation and specific recommendation to improve the understanding of res judicata, but also to improve the case law of the Court of Justice. So the book adopts here a much welcome constructive approach, which unfortunately seems to be less and less often seen in EU law doctrine. And in that respect, I mean, many chapters have excellent recommendations, but I really enjoy chapter 3 and 8, which are, in my view, very constructive and provide a lot of example and recommendation on the matter. For instance, chapter 3 provide argumentation for more explicit use of effective judicial protection in relation to the use of res judicata. And also chapter 8, also mentioned during the presentation of Araceli, provide for a more explicit use of res judicata in relation to the application of res judicata in preliminary ruling references, and especially when it comes to the effect of the judgment of the Court of Justice, which is sometimes called in the French doctrine l'autorité de la chose interprétée, and which may lead sometimes to problems. I will come back to those points a bit later. But now I will provide my last and fourth reason why I liked the book of Araceli. And the reason is because the book is about translation and comparison. Even if you do consider yourself, Araceli, as an amateur comparative lawyer, which I adopt so when I look and read your book. And you take very seriously the issue of translation and comparison, which is, in my view, the keys if one aspires to unveil the intricacies of the principle of res judicata. And in your book, Araceli, you really spot the many errors related to the translation, which has been done when it comes to from translating from French to English, and which had led to the confusion for the understanding of the principle of res judicata. So in your book, you make use of a comparative analysis, which is extremely useful to understand the tenants and aboutissants, the ins and outs of the principle of res judicata, and you also avoid the pitfalls of making use too much of comparative analysis, like Advocate General at the Court of Justice often fall in this trap, as perhaps you said that at demi-mot before. And when it comes to comparative analysis, I think there is some great discussion on the book, for instance, concerning Article 24 of the Spanish Constitution, related to the discussion on effective judicial protection. And also, I really enjoyed the reference and the discussion concerning Article 480 of the French Code of Civil Procedures, which really, I think, brings something new to the understanding of res judicata in EU law. So to conclude on my reasons, frankly, un grand bravo for all this. A big applaud for that. I've been very impressed by the presentation. So now, if I have time, I will go into the second part, the second moment of my presentation, which relates to four discussion I would like to highlight. And as I you don't need Araceli to address all the points. So afterwards, so you pick and choose what you want, to even totally ignore all what I'm saying. But concerning the first topic of discussion, it relates to chapter 2 and the source and nature of res judicata. You call in your presentation res judicata a beast. It is a beast. It's difficult to understand the source of this principle. And I call it principle, but from your book, it we saw that actually the Court of Justice only started to mention res judicata as a principle since the mid-90s. And I was wondering actually, because I think you don't go into the reason why it happened only in the mid-90s. And I was really wondering if you have an idea, why was it so? Another question related to this chapter 2, but in a way you have answered it already in your presentation. I was wondering what is your thinking around the use of comparative analysis by the court and advocate general when building the principles. But there, I think you already provide a solid answer on the matter. Concerning the second discussion, it relates to chapter 3, and I really enjoyed to read this chapter 3. As I mentioned, it includes a lot of interesting recommendations, and two of them are very much interesting. The one concerning, I already mentioned it, concerning the making the link explicit between res judicata and effective judicial protection, Article 47 of the Charter. And the other recommendation that I found very interesting, which is also a really hot topic now at the Court of Justice, is the relationship between the principle of nebis in idem and the principle of res judicata. It's a hot topic. I mean, you had all the competition case last year, Nordzucker and the B-Post, which came to life and changed the landscape in the field. Last week, you had a case actually on the relationship between res judicata and nebis in idem, which is the Volkswagen case. So I would like to hear your voice on this, if you can, and especially I think the juicy issue on this matter concern, especially the sentence in Nordzucker, where the Court of Justice states, it has been done before, I think in 2019, where the Court of Justice states that nebis in idem is the corollary of res judicata, because it seems that in your book, you don't really agree with the statement made by the Court of Justice. Third discussion possible relates to the chapter 4, the classical res judicata, as you defined and expressed in your presentation. And then there you deal, I think, brilliantly with all the case law related to res judicata and national post-autonomy, Eco-Swiss, Cap-Ferrer, Köbler, Lucchini. But you also discuss another case, the Vueling case, where you take a kind of critics towards the reasoning of the Court of Justice. It relates, I think, somehow to the comments that you made previously, but you didn't make those comments explicitly in the light of the Vueling, which is the preliminary ruling from 220 from the French Court of Cassation. So if you want to make some point on that, I will very much like it. And now let me move to my last discussion, my fourth discussion that concern my favorite chapter, the chapter 8. I think you like also this chapter 8. And I don't think it's so strange that you like your chapter 8, because the chapter 8 is really where you find the most. I mean, the chapter 8 is about the relationship res judicata, preliminary ruling, reference, preliminary ruling is the most complex relationship to me, and is where you have the less analysis in the EU law scholarship. And then you make some very interesting points with chapter 8. You have a great discussion, for instance, on the Wunschel case from 1986, where you discuss here the anomalies in translation, which led basically to the non-traduction of res judicata in the English version, and the use of a thing of binding effect instead of res judicata, and could be the source of the misunderstanding of the doctrine. So if you have comments on Wunschel, I would like very much. Another case that you mentioned very interestingly, and also connect to your presentation before, is the ICC case from 1991, the International Chemical Corporation case, where here it's really at the core of the use of res judicata, and whether the Court of Justice should use explicitly the doctrine of res judicata as absolute res judicata or relative res judicata, when it comes to preliminary ruling on validity. And I think you touch upon that in the presentation. In your book, you say, well, it's good. It seems that it will bring clarity, but you say that the practical effects will be limited. To me, I think it's not only about clarity and practical effects, it's also about legitimacy to bring clarity here. And I think actually the Court of Justice should really be very clear when to clarify what do they do in preliminary ruling on validity. And when I was reading the chapter 8, I was thinking especially about the Ligue des droits humains case concerning preliminary ruling on validity, where the court was criticized a lot to have rewritten basically the EU legislation on digitalization on the matter. If the court had clarified why, and because we are in a preliminary ruling on validity, and perhaps it's not absolute res judicata, but relative res judicata, that I think would have provided more legitimacy to what the court had done in the case. So I think I would stop here. And of course, as I said before, I let you choose to pick up whatever you want in the discussion.
Thanks indeed, Xavier. Thanks so much for these very interesting comments. And now I pass the ball to Daniel. I forgot to mention that the book has been published by Eurolive Press, and this is another reason why we invited Daniel, and we asked, Eurolive to co-organize this event. So thanks indeed, Daniel, where you are.
Thank you so much, Giuseppe. Can you hear me okay? Okay, super. Well, thank you for having me and for organizing this, or co-organizing, but you have definitely organized way much more than we have. So thanks for all your efforts. And above all, thank you to Araceli for writing this excellent book, which is, I will also show it around because I have it with me. And it's a book that it really is worth a good read. Unlike many law books, this is a book that reads very smoothly. It's entertaining. Please understand me in what sense it's entertaining. It's not a novel, but it's a book that manages to grasp the reader's attention from the very, very beginning. And the surprise I had when I read the book is that I hadn't realized how little I knew about a concept that I thought I was very much aware of. And that's one of the main reasons why I recommend the book, because it will surprise the reader in realizing how many angles still unexplored, still to be developed, the res judicata principle in EU law still provides today. So I won't go too much into the details of the book, because Xavier has already made a very nice presentation in terms of describing the main elements of the book, and of course Araceli has presented the book very beautifully. So what I will do, and in the interest of time, is just to raise a few points, which, as I was reading the book and from my own experience dealing with the case law and cases of res judicata, I would like to just throw in, and for the sake of the discussion, hear Araceli's thoughts on these points. But my first point has to do with the fact that res judicata is, and this is something that always strikes me, and when I explain it in class to students, it always becomes very striking for students and for myself. We tend to forget that res judicata is practically the only limit to the primacy of union law. The primacy of union law is absolute according to the case law of the court. It prevails over constitutional rules. It prevails over the case law of national supreme and constitutional courts, but it has one limit, and that's the principle of res judicata. Of course, it's not expressed in these terms. It's expressed in the language of legal certainty, but the principle of res judicata and the protection of stability of judicial decisions, of national judicial decisions, is practically the only exception for which the primacy of EU law must defer. So I think this shows the importance of res judicata in the overall legal system, not just in the EU legal system, but also in the legal systems of the member states, because that shows the power and the strength and the implications that dealing with res judicata actually has. Now, to make it operative and practical, there are still so many angles of res judicata which we are still pretty much in the dark. So that's why I would like to raise them. Some of them are addressed in the book, some of them are not. Some of them are indirectly addressed in the book because they're still open-ended and we don't have any answers. So first angle, res judicata in infringement procedures. And what happens when we have an infringement procedure and the member state fails to comply with the judgment, and we have an enforcement procedure, an Article 260 procedure? To what extent can the Commission bring a 260 enforcement action against the member state, and what is the remit within which that the main when bringing a 260 enforcement action? There have been some precedents in the past in the case law, but it's obvious that the court is not comfortable in giving very, very clear advice on the matter. But if there has been a ruling in an infringement procedure in which the member state has been declared to have breached union law for this and this and this fact, what happens when in the course of the enforcement procedure, the Commission brings the infringement and introduces elements of fact or elements of law and national law which were not present at the time in which the judgment was delivered? What are the limits of res judicata of the infringement judgment delivered under Article 258? And this has huge practical implications for the member states which are being sued in the context of a 260 procedure. And this is still not entirely clarified in the case law of the court. Another tricky point is when it comes, again, to enforcement, but not enforcement of judgments of infringement procedures, but enforcement of judgments in actions of annulment. And here my question is, where do we put the limit to the scope of res judicata? What is res judicata? Is it just the dispositif of the judgment? Is it the legal reasoning? And what about the facts? Where do we put the limit to what has this very strong binding force when it comes to spotting what is res judicata in a judgment? Because it might happen that what is actually res judicata in the interest of one of the parties is an assertion on a point of fact, which the court might have said that this was like this. And then the judgment is delivered by the Court of Justice, and 2 years later, it happens the Commission realizes that that was not like that it was wrong, that it was different. Then what do we do in those circumstances if we have to enforce that judgment? Or if the Commission takes measures in terms which are different from the terms of which the judgment imposed? Is that covered by the res judicata of the court's judgment? It's still blurry. We are not completely sure, but just think of the practical implications of going in one direction or going in the other. Res judicata in preliminary references. I will talk about res judicata in preliminary references is something that I agree, and the book points out to this difficulty. It's a very slippery area. Now, when we speak of preliminary references on points of law, which of course they're always on points of law, because in principle the court cannot make any rulings on points of fact in a preliminary references, although we know that the court does say quite a few things on points of fact every now and then. But when it comes to a preliminary reference judgment, what is the limit of admissibility of a preliminary reference, particularly when the court has tools to respond to judgments which have probably been responded previously on the point of law that has been questioned, which might be subject to res judicata? What happens when the court starts receiving identical references, maybe with identical facts, maybe even with identical parties, but coming from different courts in different jurisdictions of the same member state? Can the court simply make use of the reasoned order by saying that I've already solved this? Or can the court actually use admissibility tools? What happens in those situations? And the fact is that the practice there, it's a bit wobbly. We don't know if the court is happy to say that it's willing to implement its traditional res judicata approach to preliminary reference judgments in order to address future preliminary reference requests, or whether the court prefers to use the reasoned order tool, which is a more diplomatic way of telling courts to just leave me alone. I've already tackled this. It's been said before, but not coming to a decision on inadmissibility. And my final point, what is the impact of EU law, and particularly of the court's case law, of judgments of the court in final judgments of national courts? And here is where, as Araceli was saying in the book explains, we are in the territory in which probably the way in which the cases are solved depend a lot on the overall approach that the court is taking at each period in time when it comes to effectiveness of procedural law. We are now in a time of hardcore effectiveness. So since now we are in a time of hardcore effectiveness, we are seeing judgments which are much more hostile with national res judicata that breaches union law. But we might come into an era, it might not be too far away, in which there is not such hostility and the effectiveness approach becomes more relaxed. And then we start seeing more deference towards res judicata national rulings. We'll see. But nevertheless, there are some issues there. And there are some issues which are deeply entrenched, which I think they're not subject to this kind of state of mind of the case law. They're there. It's going to be very difficult to change them. And I'll give you an example, which is the classic example of Rheinmühlen. The Rheinmühlen saga, which is a variety of cases in which a national court comes to a conclusion. There is a contradiction. There's a contradictory ruling on the part of the higher court, and then the lower court, when coming again to rule in the case, makes a preliminary reference, and the Court of Justice confirms that the lower court was correct. And now, what happens with the lower court's decision, which might have been final? This happened again some years later in Elchinov. In the case of Elchinov, we had exactly the same situation in which we had a final decision of the Supreme Court, the Bulgarian Supreme Court, but now the case went again to a lower instance, although we had a final and binding judgment, because in accordance with Bulgarian procedural law, the judgment of the Supreme Court was binding the lower court and had res judicata. And nevertheless, the lower court made reference to the Court of Justice. The Court of Justice said that that lower court was right, and it had to set aside the decision of the higher Supreme Court of Bulgaria. What happens in those situations in which the court has already very clearly stated that it doesn't really care about res judicata of national decisions? And that's deeply entrenched, and that's going to be very difficult to move. In fact, the Advocate General, in the case of Elchinov, proposed the court to depart away from its Rheinmühlen stance on the argument that, well, it had to be coherent with its approach towards the res judicata final judgments in national law, which was already there, the Cap Ferro case law, etc. But the court said no. The court stuck to Rheinmühlen. So I was wondering there, Araceli, what would be your views on the long-term prospects of that scenario? So those are my points, mostly for the discussion. Thank you again for hosting me. Thanks, Araceli, for writing this book, for sharing your thoughts with all of us, and now happy to join a conversation on these topics.
Thanks indeed, Daniel, for these very interesting thoughts. And now, before giving the floor to Araceli, we have time to collect some questions or comments from the audience. So if someone wants to jump in, he or she can use the virtual hand, or can use the chat, and I will give him or the floor. Any questions or comments? Otherwise, I'm happy to ask a thing, which is 2 points actually. One is indeed the connected to what Daniel was mentioning in the very last part of his intervention. So we are in a period in which we are revisiting in a way the classics of EU law, so Chilfit, Rheinmühlen, and many others. Do you think that this will lead indeed to the overcoming of the national res Judicata sooner or later, since, if I'm not wrong, there are national legal systems in which the res judicata is not seen as an ultimate barrier. So, I mean, there are options that allow courts to question the res judicata. The first point, this is very much, I mean, related to what Daniel was saying, so nothing original. But second point, I noticed indeed that in the book you also dealt with this very dusty, I would say, discussion about the erga omnes effect of the judgment, especially of the interpretative judgments of the Court of Justice. But I would like to know a bit more about why you don't find, if I understood your point, I mean, convincing the argument used by Trabucchi, for instance. So what was trying to connect the erga omnes effect to the very special nature of the court. So why your view, I mean, this theory does not capture, I mean, what actually happens in new law in terms of lack of erga omnes or presence of erga omnes effect. And final point, since we have so many PhD students here, I would like to ask you, I mean, a piece of advice. If you were asked them to explain to our young colleagues, I mean, how to deal with cases of translation, I mean, like those you encountered in your research, what kind of criteria should we follow in order to, for instance, sometimes avoid the literal translation? So I don't know if you want to say something about that, because I think it would be extremely helpful also for our PhD students who are online with us. And finally, I see that Mariolina raised her hand, so I'm happy to give her the floor. Please, Mariolina.
Thank you very much, Giuseppe, and thank you for having organized this very nice chat. I would like to follow up perhaps on a comment which Daniel has made before, which concerns infringement proceedings and the notion of res judicata, and then the connection between 258 and 260. And it's linked specifically to this idea of systemic breaches of EU law. And the fact that the court, the court does admit, for example, in 260 proceedings that new evidence can be brought forward with respect to, the same infringement. So I was wondering whether, Araceli, you can reflect a bit on, the scope and perhaps the need for flexibility of the notion of res judicata with respect to systemic breaches of EU law that have become more and more of, a hot topic in the case law of the Court of Justice in many policy areas. Thank you.
Thanks indeed. Okay, I think perhaps, Araceli, I think that you could start with a first round of answers, and then perhaps there will be room for other comments. So, Araceli, please.
Thank you very much to all of you for your comments and questions, and for the very generous compliments of the two discussants. I don't really know where to start. I mean, if I try to answer everything, I think we'll be here for another hour, so maybe not. On the issue, because it was mentioned by two of you, the issue, yes, of enforcement proceedings under 260, I don't really have an answer in terms of how to explain the court's attitude towards kind of expanding or not expanding the scope of the infringement once you reach the stage of enforcement, which is actually not, strictly speaking, a stage where res judicata is at issue in terms of its procedural impact, because by now we are outside judicial procedure and we're kind of at a next stage, in theory, where we're looking at enforcing the initial judgment, although of course with infringement you then return before the court for actual financial penalties, but it's a very specific issue with regard to res judicata. It made me think of a presentation that we had a couple of weeks ago in Nantes by Célia Chalet, who's working on the issue of sanctions, individual sanctions in foreign, that are adopted by the council. And in particular with regard to for example, relatively recent cases of sanctions, individual sanctions, she was telling us pretty much the same thing, that the council is not really paying too much attention to what is actually in the judgment. If there's, for example, an initial judgment annulling a decision to include someone in a sanctions list for X and X reason, the council will just kind of tweak something, a little thing, and then just recreate a new decision without necessarily fully complying with res judicata. So it's interesting that we have this kind of parallel by two institutions that seem to kind of indicate that there are goals of enforcement, perhaps, that are more important to them than the strict compliance with what has been said by the EU courts in a judgment. Now, of course, the problem is, why aren't EU courts reacting to this more? Could they? Is there anything they can do to ensure that their decisions are actually really complied with by the institutions? I don't really have a very good answer to those questions. I think they're major issues of EU law enforcement and the relationship between Commission, Council on the one side and Court of Justice on the other side. On the issue of national res judicata and the way in which the case law is evolving, it's interesting because here we had Danielle with a slightly more optimistic view that maybe in the near future it's possible that the Court of Justice could give up on its strict approach to basically towards enforcing effectiveness instead of protecting national res judicata, and Giuseppe suggesting perhaps the opposite. I'm not sure. I mean, the Vueling judgment that I alluded to, and Xavier was mentioning it, is to me a very striking example of a judgment where the court seems to not really care about explaining why it's so serious a breach of EU law that we need to call into question res judicata at the national level if a cooperative mechanism between social security authorities was not followed. I mean, there's no evidence in the case that it would have made any difference, and yet the result is the same. So yes, I am pretty critical of that judgment, because I think there's this strand of case law that is moving away from trying to justify restrictions on the application of national procedural rules such as res judicata, which indeed are obstacles to the effectiveness of EU law, moving away from justifying them on the basis of effectiveness, in the sense of actually proving that there is an issue, a major issue for the enforcement of EU law, the way it was for the Italian rules on VAT rulings, for example, a few years ago, where the court said, but this is very, very bad because it's about VAT, and the national court shouldn't have decided this. It's impossible to maintain it over time. So we have to be able to call it into question. I mean, in my mind, it's related also to the growing importance of Article 47 and the fact that the Court of Justice seems to be more confident now in setting procedural standards for the whole of its judicial system. The problem is, of course, I'm not sure it has the legitimacy to do so in a system where, I mean, there hasn't really been any change in the written sources of the law with regard to the EU's competences in terms of national procedure. But I mean, only the future will tell, right? If there is a change in the ECJ's attitude towards national res judicata. In any case, yes, I agree. It is one of the important obstacles, if not one of the most important obstacles, to the effective implementation of EU law, as the court sees it, meaning taking into account the primacy aspect of EU law, where in theory, I mean, if primacy is applied, it can basically run over a lot of the law of the member states. On the other hand, it's also true, and it's a problem, that in a lot of national judicial proceedings, EU law is just applicable but not mentioned, or just lawyers and judges don't think of it, or they think of it very late in the proceedings, or they think of it 2 years later, and so there's an attempt to open a new set of proceedings, and then national judges would say, well, yes, but you know, res judicata, so too bad, you should have thought of it earlier. And because there's this problem of awareness of the applicability of EU law among lawyers and among judges at the national level, there's this contradiction between the theory of these rules being applicable and having primacy everywhere all the time in the member states, and the reality of very often these rules not being mentioned throughout perhaps even a whole first set of proceedings, all the way into appeal procedures, etc. And what do you do once you realize, oh, EU law was applicable, and if I had applied EU law, or the judge had applied EU law, then the situation would be much more favorable to me. And from the point of view of the EU, of course, any capacity, any option that exists at the national level that allows parties to call into question a final judicial decision that did not mention or apply correctly the EU rules that were applicable is perfect, right? So it's understandable, in my view, from the Court of Justice's point of view, that we should encourage parties at the national level to make use of any mechanism that exists at the national level that allows them to call into question final decisions that were made without applying EU law or without applying it correctly. For example, in cases where it is applied, but there's no preliminary reference, and so we don't apply it correctly, or there is a preliminary reference, but the court decides not to really take into account what the Court of Justice tried to answer. So that's definitely, I think, another factor to take into account. It's really, there's two sides to this, and it's very difficult to decide where to put the needle, right? What is the right balance between protecting the systems, I mean, the structures that are set up in national judicial systems that are part of the EU judicial system, and you can't upset the balance of these systems completely, and on the other hand, ensuring that EU law is applied to the extent that's possible, when we know that in a lot of cases, lawyers don't think of EU law or don't think of it soon enough for the usual national procedural rules to operate in EU law's favor. What else? Yes, one aspect on preliminary references and the use of the concept of res judicata in the context of preliminary references. I agree entirely. It's a very slippery field, and basically it's because it's the field where I think there are two problems. One is, even in national systems, the application of the concept of res judicata to all these types of preliminary questions, procedures that involve a court from a different judicial system coming in a procedure, or procedures that involve the Constitutional Court coming in and answering a question in the context of a national procedure. All of these mechanisms create questions as to what to do about res judicata, which decisions in this context have res judicata, how should res judicata operate, because you have all these decisions coming in that don't really settle the case as a whole, or sometimes don't even settle any aspect of the case as such, but settle a point of law that is necessary to decide the case. On top of that, in EU law, we have the interaction between the EU courts and the national courts. But I think that's not that different from the national systems where you have courts in different judicial orders at the national level, or courts interacting with the constitutional court, and they are having these discussions. Res judicata is always difficult to apply in these cases. On top of that, because the preliminary reference procedure has been presented historically as purely on points of law, but on the other hand, everyone was very aware that, at least with regard to preliminary rulings, they were supposed to have this ergo omnes effect. It's created this impression that only preliminary rulings have this effect, which is entirely wrong, because if you look at the case law of the court, pretty much every judgment has the potential to become a precedent that then is referred to in later case law. So there's no distinction really in that respect. And also among the lawyers from systems where the idea of ergo omnes effects of judgments was anathema, the admission of ergo omnes effects for preliminary rulings meant that these lawyers tried to develop ideas that said, well, these can't really be judgments, can they? Because they have this effect. And we know that judgments can't produce ergo omnes effect, because that's a very bad thing. So it's, I think, really, and that's, I mean, it's, for me, Trabucchi's article, for example, the classic article, has that problem, right? It's trying to come up with something that says, well, okay, we understand these have ergo omnes effects, but it's because it's a special type of judicial decision, and maybe it's not like other judgments. And in my view, this just creates more confusion. Whereas in reality, if you apply res judicata and res judicata as it is, as we understand it in domestic procedural systems, you can actually answer many of the questions that are raised in the context of preliminary reference proceedings. For example, what are the duties of national courts dealing with the same conflict between the two same parties with regard to the first preliminary ruling that was given? That is res judicata, actually. It's just, this was a judicial decision that was made in the case. And okay, it was made by a court that's in a different judicial system, but because you are integrated through this mechanism of questions, you now have to consider it part of the case that is settled. And so any court dealing with the same conflict between the same parties on the same facts will have to consider this aspect of the case settled under a specific rule related to res judicata. Now, how is that different from the duty of any other court to take into account the preliminary reference? Well, other courts aren't dealing with the same parties and the same facts in the same set of proceedings. So in that case, you fall back on, well, it's a precedent, like any other judgment from the EU Court of Justice can become a precedent, and you just have to consider the ratio of the case binding. So to me, if you think of it in terms of a common law approach, paradoxically, since every other aspect of res judicata in EU law is better understood through a civil law lens, but here, for preliminary references, I think the whole confusion about ergo omnes effects over national courts, which national courts, etc., all this confusion can be solved if you just divide really strictly the issues of res judicata themselves and the issues of broader effects of judgments, which apply to all the judgments of EU courts. And I think actually a lot of, even, as I was saying, advocate general opinions that try to deal with this issue aren't explicit enough and don't make the distinction clear enough And I think the clearer the distinction, the easier it will be to solve these issues, including these issues of what to do when we have a final judgment, etc. I think a clarification in that respect will help. I mean, at the national level, from the point of view of the court, if the national level allows an exception to res judicata, it's always good. So the court will always tell a court, if you have an option to call into question res judicata to apply EU law properly, do it. And even if you have an option, the court turns it into an obligation, doesn't it, with regard to public policy rules. So it's just the situations where you have a final judgment of a national court and then another set of proceedings was started on pretty much the same issue, but the national system doesn't consider it a violation of res judicata. The Court of Justice will say, well, it's not a violation of res judicata since the system allows it as an exception to it or doesn't consider it a violation of the principle. So no problem, go ahead and apply EU law properly. And from the point of view of national systems, indeed, there are exceptions to res judicata. There have to be exceptions to res judicata in the name of justice. I mean, there's always these mechanisms where a new element that would change the outcome of the case allows reopening at least of criminal proceedings, etc. So also taking into account decisions of constitutional courts, increasingly, just like for decisions of the European Court of Human Rights, allowing the reopening of criminal proceedings in those cases. And I think the Court of Justice for now has not required the use of all of the exceptions available for the benefit of EU law, but it's definitely a temptation. And I think here we have the conflict, right? I'm going to end my answers with this. If the court wants to develop a standard of res judicata that it wants to enforce, including not only in its own system, but in the systems of the member states, as a justification for restricting procedural autonomy, it becomes very hard to have at the same time an understanding of national res judicata as just a part of a system of norms that is simply there as a set of tools that are available for the effective application of EU law. I think it's very hard to have both understandings of national procedure in mind at the same time. Either we have a set of national judicial systems that are part of the EU judicial system that all have to comply with the same general procedural standards under the umbrella of Article 47 of the Charter, and we're all equally important and we're all giving equal importance to the same fundamental principles of procedural law. Or domestic procedure is a set of tools available to the EU to enforce EU law. And I think those are really conflicting views. I think the case law at the moment seems to be kind of shifting between the two. And this, of course, affects res judicata. And as Danielle said, and this will be my last sentence, I promise, with res judicata, it's very impressive how tweaking just one little aspect of the regime of res judicata can have major practical implications for the situation of parties to litigation at both member state and EU level. So the impact of any shift in the policy priorities that then leads to tiny changes in the way in which res judicata is understood or applied in the case law really has major practical implications. So judges and advocates general need to think about this, I think, very deeply. And that is why in the book I try to make some suggestions and mainly call for more coherence and perhaps deeper analysis of the choices that are made in the case law. Thank you.
Thank you very much. I see that Danielle raised his hand. Perhaps he wants to add something on the issue of the precedent in EU law. Who knows? Danielle, 2 points. But you have to unmute yourself.
Just 2 quick questions for Araceli.
Yeah. Two questions.
Well, one comment and one question. Very quickly, the comment. I don't think Welling is such a bad ruling. I think actually Welling is a balanced ruling, because eventually the court recognized the res judicata of the criminal ruling in the case. It's actually a situation in which what the court is stating is that, well, there is res judicata and it is to be respected by EU law. What we're not going to tolerate is its expansion. So if national law provides for mechanisms in which the definitive doctrine of a judgment expands into other legal orders, civil law, labor law, administrative law, then that doesn't work. So I think that at a general level, the Welling judgment tries to find a balance. It's not this kind of tsunami kind of approach that we've seen in other judgments, in which you can really see that the court is just doesn't care at all. It's just worries about effectiveness. But that's my understanding of Welling. A question for Araceli. Araceli, do you think that it would be feasible, considering the degree of uncertainty that we have now in defining what is res judicata let's just say in the judgments of the Court of Justice? Let's forget about national courts, but of course they're both related. But do you think it would be feasible to have a provision maybe in the statute of the court as primary law, defining precisely what is res judicata in a judgment of the Court of Judgment, in the Court of Justice, and eventually by doing that to set the conditions of what is part of the judgment as res judicata, how far does it actually go, what are the elements that comprise res judicata, and have it settled there in primary law for everyone to be aware of, instead of having to make this juggling exercise on a case-by-case basis.
Thank you. I don't know. Sorry, Araceli. I don't know if Xavier or other people from the audience wanna ask other questions. Otherwise, I will give the floor to Araceli. Okay, I see no comments or questions. So Araceli, please.
Thank you. Do I think it's possible? I mean, I'm not aware of any, but there must be somewhere, but I'm not aware of any national legislation that sets very precise rules on the contents of res judicata, exactly what is its scope in the judgments. I think, I mean, the case law does set some rules. For example, any element of fact or law that is settled, but then of course we include aspects of the reasoning that are necessary to understand what has been settled. And then we also include things that weren't explicitly settled, but must have been implicitly, because otherwise the judgment makes no sense. But of course, even under this definition, you end up with cases where it's not quite clear. But these are, I mean, reasonably precise rules. They're very similar to the ones you would find in a domestic procedural system. So not necessarily in terms of having exactly the same rules everywhere, but in terms of the degree of precision of the rules with regard to what is the res in res judicata. Is it possible to be even more precise? I'm not sure. I mean, that's the point is, I think it's also useful for courts to have res judicata be slightly malleable, something that they can change their mind over time about, in terms of what is covered by res judicata. And that's what I was saying. For example, at the moment in Luxembourg, they're having the debate that in France started 15 years ago about whether they want to include Luxembourg, I mean, Luxembourgish law, not the court, about whether we should consider that any new claim based on the same set of facts between the same parties is inadmissible, because they should have included everything in the first claim. And this is because of res judicata, because now res judicata includes everything you should have dealt with it the first time, because whenever you bring the same set of facts, the court will say, well, we've already ruled on this same set of facts, although you're bringing entirely new types of legal reasoning. And I mean, Italy also has had the same debate, I think, in procedural law. And in France, it's been ongoing for 15 years. The Supreme Court changes its mind, and then a debate started, and it's never ended. But of course, you can understand why courts want to make these changes from time to time. It's because it gives them leeway to adapt based on their policy priorities. And res judicata is, as you were saying, a tool that can adapt in very subtle ways, but these subtle adaptations create major consequences for parties. I think it's definitely something that I would welcome, at least a provision setting some of the rules, for example, at least for the cases in which you can use res judicata as a justification for inadmissibility. But then the criteria, I mean, they would have to be set in a reasonably general way. And then what are the same parties? What are the same claims? What is the same subject matter? Those are questions over which procedural lawyers have been arguing for decades, if not centuries, in domestic procedure. And they would probably argue over the same points in EU law, even if there was a provision rather than just case law settling these questions.
Brilliant, thanks indeed. So I think it's time to close this event. I want to thank once again all the speakers, starting of course with Araceli. I'm very happy, because as I said at the beginning of this event, because Araceli was also visiting Scuola here at the Sant'Anna School of Advanced Studies. And at that time, I remember she was working on this project. So I'm very happy that she finally managed to publish this important book. And I'm sure that is going to be a reference point for the debate in December. So thanks so much also to Danielle, to Eurolive, and to Xavier Groussot for the participation and their comments. And see you soon for other STALS events. Thank you. Bye-bye.
Thank you.